इसको हमने तो डायरेक्शन भी नहीं दिया, दोनों डायरेक्शन भी नहीं दिया। Was what our
Item number?
11, 12, 13.
What has happened?
That has to be heard. Yesterday also I pressed for hearing, but because the court hour finished, so I was not in the position. So let it be heard today.
It was appearing
Yes,
from the first day.
No, urgency occurred on after 13. On 13, I have received the notice. Thereafter, I have heard.
Notice as regards to, notice as regards to, notice as regards to.
Regarding they are going to demolish. On 13, they have issued the notice. And 14 happens to be holiday because PBMC was not working on that day. So 15, I have given the.
So why didn't you move it on 14th?
14 because I was not in position to serve the copy upon PBMC. Calcutta Municipal Council. On 15, I served the notice, and 16, I was before the court.
Served upon the municipal council.
Yes, sir.
And 3 others.
After the court.
When the matter will be called up, let us see.
All right. For the petitioner, my lord.
Lordship, I am appearing for the respondent, Lordship.
Dear, this is a case of electricity wherein my application was rejected on the ground that I have not provided certain documents. Lord, they have filed the affidavit in opposition wherein they have admitted that if I file a fresh application with all these documents, they will consider. That they have mentioned, my lord.
Lordship, kindly come to page number 6, paragraph number 6, Lordship.
Let me submit first, my lord.
This type of fabulous application should be dismissed with cause, Lordship.
Learned counsel, you will get the opportunity.
Lordship.
My lord, in their affidavit in opposition, page 3, my lord, they have mentioned that this petitioner has
Learned
to apply
counsel, first
his
you place your petition, your application first. What is
My-
your prayer?
my prayer for granting electricity, my lord, which was rejected on the ground that, my lord, I've applied for the electricity, my lord.
Where have you written that it has been it has been rejected?
My lord, it has mentioned. I've done it.
Paragraph number 6.
Learned counsel, let us submit.
My lord, at paragraph number 6, my lord, at page 4, my lord.
Photo obstat copy of printout of the status of rejection dated 11/6/2024. That is P2.
My lord, P2, my lord. It was rejected because I couldn't submit certain documents, my lord.
P2 is in page number
13, my lord.
Thirteen. Rejected. Submit either ration card or electoral identity card mandatorily, which you did not furnish, ration
lord.
card or electoral
On the
identity
particular
card.
time, I have not furnished, my lord.
Mhm.
That's why in this ground, they have not given any opportunity of hearing also, they have rejected.
Hmm.
Now they have stated in their paragraph, affidavit in opposition para 6, 7, my lord, that if I apply with certain documents, all these documents,
Hmm.
they will consider.
Hmm.
So what I pray, my lord, that liberty may be given, I will file a fresh application before the authority, my lord. Para 7, my lord, kindly be seen, my lord. It is submitted that the petitioner has to apply a fresh along with requisite document, my lord.
Hmm.
My lord, that I will do, my lord. That liberty may be given, my lord.
Yes, Lord Counsel. Yes, Lord Counsel. You can submit.
Lordship, kindly come to paragraph number 6 of the writ petition, Lordship.
Yes.
Shall I read, Lordship?
Yes.
That the respondent number 2 has rejected the application of the petitioner on 11/6/24 on the ground that to submit either ration card, electoral ID card, card mandatory having the same address proof of the occupancy of the premises only for the purpose of releasing of the electric connection. But this is the important. But here the petitioner has submitted her ration card along with the application and the address mentioned in the same in the said card is the same of the address mentioned as address in the application form. And kindly come to page number 14, Lordship. When the ration card has been issued after rejection of the application by the respondent authority, Lordship. Page number 14.
Yes.
Date of issuance may kindly be seen, Lordship.
25/7/2024.
Yes. Before that, we have rejected the application. How she can make this how can she can ever in this writ petition, Lordship, this type of fabulous submission? This application should be dismissed with cost, Lordship.
That's what I pray, my lord. Let it be dismissed with the liberty to file a fresh, my lord.
No, Lordship, no liberty is required.
They have admitted in the affidavit.
Let it be dismissed with cost, Lordship, because she has already submitted her submission, Lordship. My submission may be.
Yeah.
Let it be recorded, let it be dismissed with cost so that they can know that appearing before filing any application before the Honorable High Court, they have to come with clean hand.
What to be done, Lord Counsel?
My lord, now they have admitted, my lord, if I file,
Let them admit. Have you come in clean hand or not? First
my
you
lord,
submit.
it's mistake, my lord. It's mistake. It's mistake, my lord.
On affidavit, civil says it is mistake before the Honorable High Court.
It's a mistake, my lord.
Is this an application before any other forum?
My lord,
Is
first-
this an application before any other forum? The sanctity of the institution is the utmost. And if you
Deeply obliged, Lordship, deeply obliged.
that sanctity, what to be done? Can you expect the court to pass any order?
It's my mistake, my lord. My mistake, my lord. My mistake, my lord.
Mr. Bakshi. You are representing all the respondents.
Lordship,
The learned counsel. Okay. Um, The writ petitioner has approached this court as her, as her prayer for supply of electricity has been rejected by the electrical electrical by whom? Rejected by
By the petition. Rejected by the respondent number two, madam. Of executive
being rejected by the
assistant engineer, madam. Assistant engineer, electricity department. Respondent number two, madam.
page number.
Madam,
Where
14,
is that rejection?
16, 13, madam. 13.
Issued by Learned Counsel. Who issues the rejection? Who issues
It
it?
is respond number two, Lordship. Respond number two.
Being rejected by the respondent number two. Then the assistant engineer. Officer, the assistant engineer, subdivision two, electricity department, Port Blair, district, South Andaman. Full stop. To the present writ petition, the petitioner has prayed for issuance of a writ in the nature of mandamus, commanding the respondent authorities to provide electric connection in favor of the writ petitioner. Full stop. Paragraph. The learned counsel representing the writ petitioner submits that the application seeking electric connection has been rejected by the respondents on the ground of non-submission of either ration card or electoral identity card. The learned counsel further submits that there has been a mistake on the part of the writ petitioner stating that the petitioner has submitted her ration card along with the application. The learned counsel candidly submits that it has been a benevolent mistake on the part of the writ petitioner to submit such thing on affidavit, which is not correct fact. On the learned counsel further submits that she is very much apologetic for the same and prays for granting liberty to the petitioner to file, to place her application afresh. Full stop. Paragraph. Affidavit and an affidavit in opposition has been filed on behalf of the respondents. There are only two respondents. On behalf of the respondents. And from it has been taken on record. Yes. And full stop. The learned counsel representing the respondents prays for rejection of the said application with cost. Full stop. In consideration of the submissions of the learned counsels representing the petitioner and the respondents, that is electrical authority, it transpires that rejection has been order of rejection has been passed by the electrical authority on the ground that the writ petitioner could not furnish either the voter electoral identity card or the ration card in support of her contention along with the application seeking electrical connection. Full stop. From the said ration card, from the copy of the this one is the ration card.
Passion card. It's a page number.
From the
14.
Copy of the photocopy of the ration card bearing the ration card number 3530 198345 in the name of Pushpa Mondal, who is the writ petitioner. It transpires that the said ration card has been issued on 25/7/2024. That is much later than the date of application, that is 6/6/2024. Thus, there is contention in the submission, contention in the submission of the learned counsel representing the respondents. On perusal of the affidavit in opposition, it also transpires that the electrical authority, that is the respondents, have submitted that the writ petitioner has to apply afresh along with requisite document before the respondent number 2 for obtaining the electrical connection by complying the provisions of JERC. What is the full form of JERC? Learned Counsel?
Lordship,
What is the full form? Yeah. Joint Electricity Regulatory Commission, within bracket, for the state of Goa and Union Territories, bracket closed. Electricity Supply Code. Bracket. So the bracket will be closed where? After the code or after the territories?
after the territories, Lordship.
So after the code, there won't be anything.
2018, Lordship.
Regulations, 2018. Thus, from the affidavit in opposition itself, it transpires that the authority are that the electricity authorities, that is respondents, are in a position to reassess about the prayer of electricity connection if the writ petitioner applies afresh. Full stop. Paragraph. Considering considering aforesaid facts and circumstances, this court is of the view that cost of rupees 100 be imposed for
Lord, I apologize. It's my mistake, my lord, I have done it.
cost will have to be imposed. How much you submit?
Cost part, my lord.
How much? How much you submit?
The cost part, my lord, it's my mistake, my lord.
How much?
Cost has to be imposed, Lordship.
The learned counsel, your responsibility is over. How much?
The cost part, I apologize, my lord. It's my mistake, my lord. Okay.
Cost of rupees 1. Cost of rupees 1 is being imposed for such act of the petitioner. Full stop. And the purpose to provide natural justice, the petitioner shall be at liberty to file afresh and that shall be at liberty to file an application for electricity connection afresh before the authority concerned. The application is disposed of. Yes, Learned Counsel.
Obliged. Obliged.
My lord, I'm
I am appearing for the respondent authority, Lordship.
Yes, Learned Counsel.
my lord. My lord, my grandfather was encroached the government land at Ramnagar village.
It is government revenue land.
Yes,
Yes.
Ramnagar village, at Ramnagar village, Shahid Deep. And after that, the land was in my possession, my lord. And I have constructed a house in the same land. And I have submitted my application, my lord, on the 6th November 2024.
Page. Application date 6/11/2024.
Yes, my
Page
lord.
11. It's a page 15.
Yes, page 15,
Thereafter?
P1.
Thereafter,
My lord, in the same day, it was rejected.
why?
Remarks will be given to us in page number 23, my lord.
Page number 23.
Yes,
Remarks. As per Tehsildar letter, land revenue and land reforms regulation 1966 strongly condemn any connection on government encroached land.
my lord, my lord, there was a scheme.
So you are occupying a government encroached land wherein
My grandfather was occupied.
now you are in
Now
possession.
I'm in position.
That the Tehsildar has opposed to that. Yes. Now,
My lord, there was a scheme formulated by the government of India that encroached the government revenue land after to 1978, but prior to April 1993. My lord, as per the opposition, my lord, I'm not claim my benefit, or I'm not claim the electricity as per this scheme, my lord. I'm not getting the electricity as per this scheme in their opposition. But my lord, if I'm not getting this electricity as per this scheme, but I am getting but I can get my electricity connection through the ruling of larger bench of Calcutta High Court, my lord. My lord, in opposition, my lord, there was a in my lord, kindly come to the page number 19, my lord. In opposition,
what is a prayer?
my prayer is to grant provide electricity connection in the premises of the petitioner, my lord.
Provide electric connection forthwith to the house of the petitioner standing on survey number 153,
Yes,
measuring an area of 500 square meters at Ramnagar village. Yes. On what basis?
my lord, in copy of opposition, my lord, kindly
In your petition, what you have stated? Are you relying upon the respondents? Your contention is that you are in occupation in respect to the said property since prior to 30th April 1993. So you can be provided with electric connection. Yes, Learned Counsel.
Lordship, kindly come to the opposition page number 7, Lordship. The scheme which she is speaking about.
Page 7.
Lordship, my opposition, Lordship.
Can you place it? What is the scheme about?
Lordship, kindly, can I read first paragraph, Lordship?
Yes, place it.
Kindly refer this ministry letter of even number dated 7th February 2013 and reminder dated for 4th March 2000 2003 and 27 March 2000 regarding follow-up action of the statements made by the Honorable Prime Minister on 20th January 2000. During the last visit, the Andaman Nicobar, the provision of electricity connection, water tap connection to the people residing on the revenue land up till March 1993. When petitioner has borne lordship, kindly go through the writ petition lordship.
Provision of electricity and drinking water connection to the people residing on revenue land.
Prior to 90, cutoff date is there lordship. Prior to 1993,
Yes. Yes.
March 1993.
Yes.
Kindly come to page number 24 of the writ petition lordship. When writ petitioner has borne
Yes.
in the year 1988.
Yes. 1988.
At the age of 5 years, he will encroach a land. Whether it is possible, lordship.
It is the submission, wherein you have stated that it was enclosed by your grandfather. Wherein you have stated, Learned Counsel? In which paragraph?
My lord,
You
I
should
not
have,
mentioned that.
you should have come after going through the record. In which paragraph you have stated?
It is not there, lord.
Hmm?
I'm
It is not there. I have seen each and every paragraph.
The respondent number 2, why repairs not published. But after prior to the repetition. That after 1978, but prior to the mentioning a petition occupied a piece of government revenue land. Dwelling house and residing on a panel. It's a piece of land. It is a submission of the Learned Counsel that it was occupied by his grandfather.
So how he can file an affidavit saying that I have encroached the government revenue land before the authority? Page number 16.
What to be done, Learned Counsel?
It has to be dismissed with cost lordship.
Liberty may be granted, my lord.
My submission may be recorded and it should be dismissed with cost at least.
My lord, I
They
What?
filed,
should come with clean hand before the Honorable High Court lordship. They are playing with the code.
Yes.
my liberty may be granted, my lord.
Hmm.
I filed my fresh writ petition.
And kindly come to page number 25, lordship. It is a dwelling house or it is a hut for the purpose of giving it to tourists. Page number 25, photographs they have enclosed in the writ petition.
that you will inspect that you will make inquiry after fresh application being filed.
Lordship, no fresh application should be allowed, Lordship. This type of application should be dismissed, Lordship. My submission may be recorded. No fresh application should be allowed, Lordship.
The Learned Counsel, the present writ petition has been preferred by the petitioner seeking electricity connection in respect of the property situated at situated a property being a government revenue land bearing survey number 153, measuring an area of 500 square meters, situated at Ramnagar village, Shohid Deep under Port Blair Tehsil District, South Andaman. The the respondents have filed affidavit in opposition against the said writ application. Full stop. Wherein they have denied the contentions. The respondents have denied the contentions made by the petitioner. Full stop. Paragraph. The learned counsel, the learned advocate representing the petitioner submits that the grandfather of the petitioner had encroached the government revenue land in question. Government revenue land wherein the petitioner is seeking electric connection to be provided, and that was prior to 30th April 1993. Full stop. Full stop. She further submits that as per the scheme, in which page it is the scheme is, as per the scheme, in which page is the scheme? Learned counsel, in which page is the scheme?
Page number
At
5.
least henceforth come prepared. Otherwise, ask your learned senior to come.
Page number 5.
Page number 5 of
Page number 7 of my opposition, Lordship.
7 of your
Petition.
last line. As per the scheme, dated 9th May 2003.
Lordship.
9th May 2003. It has been laid down that the encroachers of government land prior to the encroachers of government land shall be provided with electricity and drinking water connection. Encroachers of government revenue land. Who have encroached prior to March 1993. 1993. That was the last line. Provided with electricity and drinking water. The last line starts with. She further submits that as per the scheme, this is 9 which has been opened that includes for government level will have approached prior to March 1993. They have to are to be provided with electricity and water connection, drinking water connection. Relying upon such scheme, the learned counsel seeks relief as per the application, as per the prayer made in the writ application, writ petition. Full stop. The learned counsel representing the respondents brings to the notice of the court the, what were you showing? That document, which document? Where from the date of birth was revealing?
In the writ petition, Lordship.
Writ petition, page number
24.
Lord.
24. Yes. What was the last line? Respondent brings to the notice of the court. To the court, page number 24, that is, wherein the photocopy of the unique identification, Aadhaar card has been provided and points out that the date of birth of the petitioner is 9/1/1988. As such, prior to the year prior to March 1993, the age of the petitioner, during the month of March 1993, the age of the petitioner would have been only 5 years, and it was not possible for a child of 5 years to encroach upon a government revenue land. As such, the learned counsel prays for rejection of the rejection of the application, writ petition. First one. On consideration of the writ petition, contentions on consideration of the contentions made in the writ petition and the affidavit in opposition and the submissions of the learned counsels representing the petitioner and the respondents, it transpires that the scheme which the petitioner is banking upon is a scheme wherein persons occupying government revenue land prior to March 1993 are provided with electric connection. Herein, the petitioner from the Aadhaar card furnished, it transpires that the age of the petitioner was 5 years at the time of 5 years during the month of March 1993. As such, it is hard to believe that a child of 5 years will be able that a child of 5 years will encroach on government revenue land. In such circumstance, the present writ petition is dismissed without any cost.
Obliged, Lords.
In this matter, I'm for the petitioner. I'm sitting there.
I am appealing for the respondent, Lordship.
For the judgment passed by this honorable court, my application, which is at page 8, online application, till date has not been disposed of. Last occasion, I actually filed the order was filed by the learned friend with regard to the identical matter which has been disposed of by the court number 1, your lordship, that is also in the file. My online application is page number 8 here.
What is the fact here?
Same, your lordship, government revenue land secured by me.
1 minute, 1 minute. It is government revenue land.
Yes, your lordship, no doubt.
Uh,
I'm just seeking the benefit of the.
What is the, where is the land situated?
It's Calcutta wood value. My
It
Blair
is
page
survey number
Page
167
Lordship,
P,
lordship,
area 300 square meters, situated at Kettleganj.
Cattleganj village, Paragal Tehsil,
Kettleganj village, Frederganj,
Tehsil,
Tehsil,
Southern
South Andaman
Lordship.
district. Government revenue land.
Lordship.
You have been encroaching. Yes.
I'm in the settled position of the land,
Mhm.
and as per the judgment passed by this honorable court,
Mhm.
I applied through online, your lordship,
Hmm.
my page number 8 may be seen, lordship.
Page number 8
8.
on 21/9/2024.
Yes, along with the requisite documents, your lordship.
You have filed all the requisite documents.
Lordship, in this petition, I am not getting the Aadhaar card. I have not enclosed, your lordship, but the affidavits, indemnity bond, and the undertaking I will file. My application has been not disposed of till date, your lordship.
Not disposed of till date. Learned Council, not disposed of till date.
Lordship, we will consider and dispose of the application filed by the writ petitioner.
The Learned Council. The petitioner, the petitioner, writ petitioner here, herein has preferred the present writ petition. Being compelled as because her application dated 21/9/2024 seeking electrical connection in respect of the government revenue land bearing the survey number 167 by P, situated at CADDLE GUNG village. It is pronounced as
Cattleganj.
Kettleganj, Tehsil Ferrarganj, within the district of South Andaman. What has been the sentence? Has not yet been disposed of by the respondent, disposed of by the electrical authority. Full stop. The Learned Council, hold on, no affidavit in opposition has been filed on behalf of the respondent. Full stop. The Learned Council paragraph, Learned Council, the matter is taken up for hearing. The matter is taken up for hearing. Full stop. The Learned Council representing the petitioner submits that in spite of an application for electrical connection being made on 21/9/2024, the respondent, that is the electrical authority, has not disposed of the said application till date. As such, the petitioner has been compelled to approach this court seeking direction upon the respondent to dispose of the application. What is the prayer?
Dispose of the representation.
Disposal of the writ application. No, your prayer is to
No, it is-
provide electricity.
No, dispose of the representation and to provide. Okay.
To
Nature of
dispose of the representation
And to
and to provide electricity. Full stop. The paragraph, the learned counsel representing the respondent has been candid as usual, has been candid enough to submit that the said application filed by the petitioner shall be disposed of by the electrical authority at the earliest. At the earliest, full stop. Considering the writ application and the submission of the learned counsels, this court directs the respondent, that is the electrical authority, to consider the application filed by the writ petitioner dated 21/9/2024 at the within learned counsel within
4 weeks, Lordship, 4 weeks.
within 4 weeks from the date of communication of this order,
Lordship.
from the date of communication of this order to the respondent number 2, and to pass a reasoned order and to provide a copy of the reasoned order to the petitioner. Full stop. If the application is disposed of in the affirmative, then the further steps shall have to be taken within
2 weeks.
2 weeks thereafter. The writ petition is disposed of.
The last line.
Obliged, Lord.
I think there is respondent number 2 has been retired.
Respondent,
It is
it's
sole
sole respondent. There's one respondent only.
Only respondent.
Lordship.
Respondent, that is the electrical authority.
If you have.
Lordship, item number 4, I need to file the affidavit in opposition, Lordship.
Why?
There
What?
is certain difficulty, Lordship. I have to file, Lordship. I may be permitted to file the opposition, Lordship.
What for, learned counsel? What for?
I have to bring certain fact on record by way of an affidavit in opposition, Lordship. So let it be in the next circuit bench. In the meantime, I will file the opposition.
Why not on Monday?
Lordship, within 1 day, I have already explained your Lordship because it has to go through various wings of the administration. So
The the learned counsel representing the respondents submits that the respondents need to file an affidavit in opposition, as such seeks a week's time. Let the
2 weeks, 2 weeks may be granted, Lordship, at least.
fortnight, seeks fortnight. Let the matter appear before the next available.
Obliged, Lordship. Deeply obliged.
Has it been shown to an adversary?
Same copy I have supplied to the others. Order number 7, 21, 2021. Today, we are filing receipt of payment of cost and deposits. Both parties have filed their respective hajra. An application has been filed by the defendant paying for issuance of writ upon the local inspection commissioner. The petition has been along with requisites and receipt of fees of the landed commissioner. At the landed council, as the commissioner fees have already been paid to the landed inspection commissioner, Shri Padesha Bunda, advocate. Then the prayer for issuance of writ is considered and allowed. Let the writ be issued upon the landed inspection commissioner, Shri Padesha Bunda, advocate for holding legal inspection over the property as per the point mentioned in the petition. 6/28/10/2000 for commissioner report. Now thereafter, order number 8, suit has been transferred from the court of landed civil justice to the landed court of landed joint civil. Order number 8, 27/9/2024, in view of the office order number 914, dated 24/9/2024, passed by the landed district and session judge, Andaman Nicobar Islands, Port Blair. The case is withdrawn from this court and transferred the same for trial and disposal to the file of the joint civil justice at Port Blair. Let the case record be sent to the court of joint civil justice Port Blair today. Now, present Sri Pavitra Sen, joint civil justice, order number 9, 18/10/2024, received the case record on being transferred from landed civil justice Port Blair in view of office order number 914, dated 24/9/2021, passed by the landed district judge Port Blair. Let the case record be registered in other suit register by number 153 of 2024 to 28/10/2024 for appearance of the parties. Now, order number 10, 28/10/2024. Today is fixed for appearance of the parties. Learned advocate for the plaintiff and the defendant are present by way of filing their respective hajras. Learned advocate commissioner filed his report in the closed envelope. Commissioner report is open in presence of both parties. Both sides having no objection in connection to commissioner's report at both sides to 8/10/2024 for order.
What more is required?
Order means the order in respect to the acceptance of the commissioner.
What is saying?
None of the order means what? No hearing, nothing.
Order 39, rule 1 and 2 was heard on that particular
No.
date and thereafter order was passed.
No.
What is saying no?
No,
That is, we were
Nothing was
present
done.
there. It was heard on that day.
commissioner report was opened. Both the parties accepted the commissioner report.
Yes, there's no
The date
question.
has been fixed for acceptance of the.
No, 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 no.
Let us now come to the next order.
Yes, next order.
Next order has been
The input.
annexed.
It is already there in the impute order. Actually,
Impute
by
order.
mistake, the number is same. By mistake, the date is different.
That I was thinking.
Order is different.
Order date is different.
The page number.
That is at page number. After page number 122. 35 copies to.
Acha, हाँ.
Date is different.
Uh,
By mistake, a typographical error may be there.
Despite accepting the commissioner report.
8/11/2024.
Yes.
Yes.
This one was on 18/10/2024.
Yes.
2810. 2810, not 1810. 2810.
For 28/10.
Yes.
28/10. 28/10. Then I vote for the contesting parties are present. Today's issue order. Learned advocates for the contesting parties are present.
Yes.
Today is fixed for order. Peruse the commissioner report and the material on record in view of the fact that the inspection report is in resonance with the points that were asked for to be inspected and no challenge is raised regarding the inspection report of the commissioner. I am inclined to allow the petition dated 22/7/2024. That is the
application under order 30 rule 1 and 2,
Rule
read
1
with
and
section 1.
read with section 151. According to the petition filed on 22/7/2024 under order 39, rule 1 and 2, read with section 151 of CBC is allowed on condition and Learned counsel.
When the
Was
hearing
heard.
was
Learned counsel,
Hearing was
first of
done on that
all,
particular date.
he will have to think that you are a court officer.
My lord.
It
My
was
lord,
heard on that
last
particular
order
day. We participated
Commissioner
in the
report
hearing.
was opened in open court, nobody raised objection, fixed the date for passing order in respect to the acceptance of commission report. And on that
Learned
day,
counsel, is this learned counsel, first of all? Is this a commission report as regards to partition after
no.
preliminary decree?
No,
Order
For
39
filing,
for
inspection report,
for granting the final decree?
inspection report, inspection report.
Ah.
Inspection report, nobody challenged the inspection report as because the
Learned counsel,
commissioner.
learned counsel. As regards to these commission reports, not a partition commission report.
Yes,
We are going to order 39, rule 7,
Seven.
Yes.
local inspection commission held by an advocate,
yes,
generally by an advocate.
yes.
Therein, if there is any specific allegation or any objection is raised, otherwise that
Otherwise, without
Otherwise-
checking, I am asking myself, my lord,
was
without
not
hearing
that
the
is-
application,
It was heard
without
on
a
that.
written objection, whether order can be passed.
It was heard on that.
Without hearing, no hearing was,
Yes.
it is
No, no,
fixed for order.
It
It
was
was
heard
fixed for
on that
order.
particular date and thereafter order was passed.
If learned trial court ought to have fixed the matter for hearing of that application,
learned counsel.
ought to have fixed the date for hearing of that application. No hearing order has been passed against me.
It was.
Even my written objection was not there.
Hearing was.
No hearing was conducted. Even the order sheet says.
Heard both sides. What does it mean?
Previous,
It's unnecessary.
previous order.
He's
The previous order
practically
itself
making
shows that
aspersion
no
against
hearing
the
was
learned trial court.
Conducted. Previous order itself shows no hearing was conducted. All the previous order I have given, no hearing was conducted, fixed for order. Order means order in respect to what? Commissioner was, it is not the earlier order, it is not their thing, hearing was concluded. And it is fixed for
Commissioner's
this year.
report is not an
Only thing is the
application.
commissioner report
That for
is
that
present
purpose,
for
any
both
order is to be
parties.
passed.
Both sides
What
having
is
no
submitting?
objection in connection with the commissioner report, fixed for order.
No.
So
Heard
while
that.
it is mentioned.
heard
that the
both
hearing was
sides and
concluded
thereafter
with
fixed
respect
for
to
order.
application under order 13, rule 1 and 2. There is nothing.
He's going
Only-
technically
No, not
Yes.
technically.
because a technical objection is
Even,
made
even
here.
I am the,
Commissioner's
plaintiff.
report is a report, not an
if
application.
opposite parties are enjoying my property without any funding, I filed a suit for recovery of possession and without hearing the order has been passed.
It was
The
heard.
last
Order
by
39,
the
rule 1 and 2 was
order-
heard on that particular day and thereafter order was passed.
2024, where it has been mentioned that the hearing was concluded in respect to order 39, rule 1 and 2, reduced 151.
It is clearly
Only that
mentioned.
commissioner report is open in presence of both parties, both sides having no objection in connection with commissioner report. Heard both sides.
Yes, heard both
Heard
sides.
both sides with the what hard? That
Order
application was
39,
not heard.
rule 1 and 2 was
Hard
heard.
both sides means
What is
in respect
submitting?
to commissioner report.
Hmm.
Nobody challenged the commissioner report, that was hard.
Learned counsel. If that be so,
Yes,
for the
my lord. Nobody challenged the commissioner report, that was hard.
That is not an
Thereafter, the
application, sir.
application was not hard.
Commissioner's report is not an application which is to be heard.
learned advocate commissioner filed his report in closed envelope.
Yes,
Commissioner report is open in presence of both the parties.
Yes.
Both sides. Ajay, both sides having no objection in connection to commissioner's report.
yes.
And it is presumed that commission took place in presence of both sides.
Yes.
So if commission takes place in presence of both sides and if there is no objection as regards to the commissioner's report, what will the court hear as regards to the commissioner's report?
No, court will not hear.
Please
Court will
explain.
fix a date
No,
for
no,
hearing of
no,
her application as well as my
explain-
application.
That was
Explain
heard
to
on
this-
that date.
Explain to this court as to commission was held for 1 day or 2 days or 3 days, whatever maybe number of days, during the presence of both the plaintiff and the defendant. There is no hindrance and there is no objection as regards to that.
Yes.
Herein, commission report has been filed. Both sides having no objection in connection to commissioner's report. What further is to be heard as regards to commissioner's report?
No hearing is required because both the parties
Yes.
accept the commissioner. Hearing is
Commissioner's report
required for
Commissioner's report accepted.
accepted.
Thereafter, heard both sides.
Now, heard both
To
sides.
8/11/2024 for order.
hard both side means hard both side, I have not objected the commissioner report. They have
What has
also
been
not
heard?
objected
What
the
has
commissioner.
been,
That was hard.
what has been heard except that application? What has been heard?
Nothing
Heard
was
both
heard on
sides
that
been-
day.
It was
Only
already
this-
rule
this
was
was-
heard.
No.
The
Yes,
trial court asked for the whether you have any
He's-
objection regarding the commissioner report. We both said no. You
Yes.
don't have any objection.
And
That
then
was
order
hard.
39 rule
That
was
was
heard,
for order.
and thereafter it
But
was
no
fixed for
date
order.
has been fixed for hearing of the application under order 39(1) and 2.
Learned
And
counsel.
in my
The
absence. the
Expulsion
order
is
has been
looking
passed.
practical. Yes,
No, this is not.
order 39 rule 1 and 2 was heard on that particular.
No,
day.
no.
That's why heard
No,
both the
no.
parties.
There is.
What hearing will do,
Order-
what hearing
not
court will
reflect
do.
that. It was hard.
It
Order
was
does not reflect that.
clearly reflects.
Mr. Bokshi.
Order does not reflect that. Now my property, they are enjoying, they are renovating the resort, they are starting the resort without further. Even after last day I produced on judgment also of the Honorable Supreme Court that they don't have any right over the property.
That I have
After
seen,
the
judgment,
expiry
it has got nothing to
After
do
the
with the
expiry
instant
of
case.
the lease period, 2021 lease period expired.
That judgment
They are
has got
another
nothing to do with this instant case.
And without hearing me, that order was passed.
Complete submission complete.
My lord.
The learned counsel, representing the petitioner plaintiff furnishes a typed copy of the order dated 21/8/2024. Orders of the orders dated 21/8/2024, 27/9/2024, 18/10/2024, 28/10/2000 and 28/10/2024. Orders dated 21/8/2024, 27/9/2024, 18/10/2024 and 28/10/2024. Let the typed copy of the orders be kept with the record. Full stop. Okay. Just prior to that, the learned counsel, in the middle, after the dates, the learned counsel representing the respondents, opposite parties, does not raise any objection as regards to the typed copy of the orders passed, filed today. Achha. I've missed one thing. Passed in other suit number 153 of 2024. The number remains the same. Wherever it is transferred.
Earlier it was other suit number 6 of 2024. After transfer, the renumbered as 153.
Yes.
Achha. Passed in the other suit passed in the other suit, which was initially numbered as
6 of 2024. Other suit number 6 of 2024.
which was initially numbered as 6, other suit number OS 6 of 2024, and presently being transferred to the court of
Joint Civil Justice Senior Division.
Joint Civil Judge Senior Division, South Andaman, Port Blair. It has been renumbered as one other suit OS, other suit number 153 of 2024. Full stop.
My injunction application has been
Press for it.
infractions.
Press
Have
for
you,
it.
have you read anything
No,
to this?
Yes.
no.
My division of, I have prayed that let both the application be heard together
No.
and order passed simultaneously. Because my application has become infractuous. I prayed for restraining the defendant not to make any construction of it here. That is pending.
The learned counsel, representing the aggrieved party submits that without hearing the learned counsel representing the petitioner plaintiff, the prayer sought for by the defendants before the trial court, seeking repair of the building or the repair of the resort, seeking repair of the resort has been allowed, which is against the provisions of law. The learned counsel further submits that the application which has been filed on behalf of the petitioner plaintiff before the trial court under Order 31 Rules 1 and 2, read with Section 151, has not yet been
Disposed.
heard
His
or
application.
disposed of. And prays for disposal of the said application. Full stop.
My submission, my application has become infractions.
He may say so,
Because
but it can
my
be heard.
application is not restraining them not to make any repair. Their
No,
application to
no,
repair.
no.
When their application has been allowed, my application.
No,
has
his
become
application
infractions.
is not for restraining us from repair. Restraining us from carrying out construction over
Then
there.
let us go.
Both
My
the things are
application I have
totally
enclosed.
different.
I have enclosed my application. Along with
Show
the-
restraining from carrying out any construction.
My application, yes. Where identity injunction, temporary injunction, restraining the agent not to make renovation.
Renovation. Repair is not
They are
there.
doing the renovation,
We are doing repair.
renovation of resort standing on this footland and
Learned
not to
counsel,
make any
learned
construction.
counsel, there is difference between renovation and repair.
Actually, they are renovating.
That you can agitate before the trial court
Yes.
if they do so.
My submission, what remain in my application, nothing.
Disposed of. Full stop. The learned counsel, representing the respondents, opposite parties, submits, from senior counsel submits that through the application under Order 39, Rules 1 and 2, read with Section 151 of the Code of Civil Procedure, the respondents, defendants had prayed for repairs of the resort, of the said resort Has the said hard copy been provided in respect of that judgment?
Provided.
In the second
Second
appeal,
appeal, yes.
provided. Have you gone through?
I have not gone through it.
Because in the SCC, I couldn't find that AIR Travancore. I couldn't find in the SCC. That's why
Somewhere they
I asked for the hard copy. Hard copy provided.
provide. Copy was supplied to me.
Hmm.
You can say it's
My lord, in this case, my lord has directed me to produce the record from the Mayabandar district. I have inquired, my lord, they have tried.
Hmm.
And since it is this pertaining to the period 89, 90, 96, and at that time it was under the Andaman district.
Hmm.
After that, the Mayabandar district has been bifurcated.
Hmm.
So some time is required, my lord, for bringing the record. Pertaining to whole record.
I'll reduce the pain of my learned brother. There are two folder directions, but not his last order. First, I have to file the draft type copy of that record entry which I brought. If not is satisfied, even the other side is satisfied, no record is required. I'm giving.
Provide a copy.
Malum. Same thing. I have left no stone unturned to detect everything, and it's in terms of the records.
Even then, my lord, I will take time, my lord, to check with the office, the documents.
Substantial hearing was done. What needs to be done?
RC number 54 of 76.
You have filed
Mayabandar.
in your opposition. That's the thing.
No, my lord.
You have filed opposition.
No, they have filed.
We have
opposition.
filed our opposition.
Part
Not
of
counsel.
My lord has,
Not counsel, no.
I'm not using
my lord,
reply.
after seeing the opposition, my lord has directed me to produce.
Heard out.
And you have filed the affidavit in opposition, and in addition to that, on the earlier occasion, you have submitted that when you were asked for that is the word resumed
Yes,
mentioned
yes,
there.
yes.
Yes.
You have submitted that yes.
Yes, my lord.
So learned counsel, there is no. I don't think there is any cause for adjournment being sought for. Herein, you have sought for
Presumption is bad.
1 minute, 1 minute.
The
As far as 1 minute.
last order
Let me go through the.
yes, last order. Everything has been recorded by my lord.
Learned counsel representing the petitioner submits that the matter involves only question of law. Therefore, learned counsel representing the petitioner submits that the petitioner has been compelled to approach this court because of the wrong recording in the record of rights. Wrong recording in the record of rights, that is resumed.
Resumption. That
Resumption.
remark column.
Or holding registered in respect of survey number 26, measuring 0.69 hectare of land according paddy 2. What does paddy 2, is there anything paddy 1?
It's another, it's paddy, the term is decisive. Paddy means cultivation,
Hmm.
class of crops.
Why it is
Rabi
mentioned,
crops,
why it is mentioned paddy 2, Roman
no, it's
2?
rabi crops falls under paddy 1.
Acha.
Kharif crops falls under paddy 2. House side means house side,
Oh,
commercial side,
Rabi falls under paddy
1,
1.
yes.
Kharif falls
Yes.
under paddy 2.
2. It's a term is decisive, I have said. A cultivation is to be done.
Cultivation. Survey number 27, classified as H, hill. H means hill.
House side,
Oh, house.
house side. Hill means hilly would be written, HILLY would be written.
H means house.
House side.
And survey number 70, measuring on the hectare. Father of petitioner says receipt, and the wrong does mention that the holding has been Donald counsel further submits the right in respect of land habitat be home or paddy can be relinquished only by two. So according to your contention is that home, either it be home or paddy, it can be relinquished only by two provisions.
Yes, ma'am.
One through abandonment of holding.
Under 152, the regulation.
Regulation. Regulation. It is there.
There is a book.
Yes.
Ella.
Land Revenue and Land Reforms Regulation,
Yes, ma'am.
1966.
66.
There is one thing.
Municipal
That is
regulation.
municipal
Municipal
regulation
regulation.
64.
Municipal regulation, 1994. 152 is the provision dealing with amendment. Authority has been recognized. Inquiry needs to be made
One minute, one.
at page 28. Page 28 of the book.
So according to you, there are um two methods.
My lord.
Three.
Three.
One is ejectment of tenant, that is 151.
No. 152 amendment.
No. By three ways, they can
Property can be taken away.
property can be taken away.
Yes.
First one is 151. That is, a tenant shall be liable to be ejected from his holding by an order of the SDO made on any of the following grounds. First, he has done
Yes.
any act which is
Yes.
destructive or permanent injurious
Yes.
to the land comprising the holding.
Yes.
Second one is he has used such land for any purpose other than for which it was given.
Yes.
C is he has transferred his interest in such land in contravention of the provisions of this regulation or any rule made thereunder.
My lord.
No order under subsection 1 shall be passed unless the subdivisional officer has by notice called upon the tenant to show cause against his ejectment.
No, this was,
In this
it has not been followed.
in this case, no no order under subsection 1 has been passed.
My lord.
It is, but no notice has been issued upon
My
you.
lord. My lord.
The second one is abandonment of holding,
My lord.
where during the period of one agricultural year, an occupancy tenant or a non-occupancy tenant does not cultivate his holding or leaves the locality in which he usually resides without making any arrangement for the cultivation of the holding, or a grantee does not cultivate the holdings given under the grant or leaves the village in which he usually resides without making proper arrangement for the maintenance of the holding given under the grant, the subdivisional officer may, after such inquiry as he may deem necessary, take possession of the land comprising the holding and arrange for its cultivation and upkeep by letting it out for a period of one agricultural year at a time on behalf of such occupancy tenant, non-occupancy tenant or grantee. What is the difference between occupancy tenant and a
My lord, kindly
non-occupancy?
turns to 141. Then what is occupancy, what is non-occupancy has been defined. Regulation 141. My lord would find at page 25. Classes of tenant under chapter Roman 13.
Occupancy tenants, non-occupancy
And
tenants.
now kindly see 142. Occupancy tenants have been defined.
Every person belonging to any of the following classes shall be called an occupancy tenant and shall have all the rights and be subject to all liabilities conferred or imposed upon an occupancy tenant by or under this regulation, namely, every person who immediately before the commencement of this regulation has acquired the right of occupancy under the provisions of the Andaman and Nicobar Islands Land Tenure Regulations 1926. So who has immediately who had already acquired the right of occupancy
My lord, under the erstwhile tenure, 1926 tenure.
under the provisions of the Andaman and Nicobar Islands Regulation 1926
my
land
lord.
tenure. And
B, my lord.
every person who has as a non-occupancy tenant cultivated any holding not being a holding situated within the local limits of the Port Blair Municipal
Yes.
Board. So it should be beyond the jurisdiction.
My lord, the present landfill property is beyond the Port Blair municipal limit. It's within Diglipur Tahsil.
Municipality, Port Blair Municipal Board and Port Blair Municipal Council same.
One and same.
One and same.
Erstwhile it was board, now council.
Now
Council.
continuously for a period of 2 years from the commencement of this regulation or of such tenancy, whichever is latter, in accordance with the provisions of this regulation and is not arrears of land revenue. Achha. Non-occupancy tenants. Every person belonging to any of the following classes shall be called a non-occupancy tenant and shall have all the rights and be subject to all the liabilities conferred or imposed upon a non-occupancy tenant by or under this regulation. Every person who immediately before the commencement of this regulation was a non-occupied tenant under the provisions of the Andaman and Nicobar Islands Land Tenure Regulation 26. Every person who is guaranteed a license under clause 2 of section 146 in respect of any agricultural land.
Next is license grantee, I think we are not concerned with,
Hmm.
and no and now. The present land is over, occupancy right now.
Yes.
And the third mode is not
Surrender.
surrender, voluntary act of my father.
Hmm.
There's no papers, no discussion, nothing in the opposition, but the opposition says it has been surrendered. There has to be papers of my father surrendering it voluntarily to the Tahsildar.
Where such occupancy tenant, non-occupancy tenant or the grantee or any other person lawfully entitled to land claims it within a period of 3 years from the commencement of the agricultural year. So, they are relying upon 152.
Well,
You are relying upon section 152 of the regulation. 1966, that council, Mr. Siva Balan,
My lord,
you are relying upon 152.
my lord. Even in the document, in the remarks
No.
column, it is written as deserted.
Now, only writing won't suffice.
No, this is the entry made by the revenue authorities after inspection of the field. And the deserted means they have abandoned it.
That's why this code is saying that you are relying upon
Yes,
152,
152, my lord.
1A. 152, 1A.
My lord.
Place 152, 1A.
Four, my lord. 152, 4.
152, 4. Where a holding is decided
Abandoned.
abandoned. Achha, where a holding is decided abandoned under subsection 3. When no claim is preferred under subsection 2, or if a claim is preferred and disallowed, the subdivisional officer shall make an order declaring the holding abandoned, and the holding shall vest absolutely in the government from such date as may be specified. When no claim is preferred under subsection 2, when such occupancy tenant, non-occupancy tenant, or a grantee, or any other person lawfully entitled to the land claims it within a period of 3 years from the commencement of the agricultural year next, following the date on which the subdivision officer took possession of the land, it shall be restored to him on payment of the dues also. So it can be taken over if 1 year cultivation has not been done.
My lord.
Thereafter, section 152, subsection 2 states where such occupancy tenant, non-occupancy tenant, or grantee, or
Yes.
any other person lawfully entitled to the land claims it within a period of 3 years
My lord.
from the commencement of the agricultural year. Next, following the date on which the subdivisional officer took possession of the land, it shall be restored to him
My lord.
on payment of the dues, if any,
My lord.
and on such terms and conditions as the subdivisional officer may think fit.
My lord.
Herein, you have stated that his father,
During his lifetime, never claimed.
Fokit Chand Chaukidar,
Yes, my lord.
never paid
Land revenue.
Nor in his lifetime, nor
Occupied.
nor
Occupied
his
the
legal
land.
heirs,
Not occupied the land. Even
nor occupied the land.
occupied the land for 22 years.
Provided that no such land shall be restored to the possession of the tenant or grantee or other person unless the period for which such land has been let out by the subdivisional officer under subsection 1 has expired. When no claim is preferred under subsection 2, or if a claim is preferred and disallowed, the subdivisional, when no claim is preferred under subsection 2, or if a claim is preferred and disallowed by subdivisional officer, can make an order declaring the holding abandoned, and the holding shall vest absolutely in the government from such date as may be specified in that behalf in the order. Where a holding is decided abandoned under subsection 3, the liability of such occupancy tenant, non-occupancy tenant, or grantee for the areas of revenue due from him in respect thereof shall stand discharged. So you are relying upon this
My lord,
4. 2, 3, 4. Yes,
3 and
anything more to be submitted on your behalf?
my lord, and limitation also, my lord. They have never claimed, if as per within 3 years, no claim was made. So barred by limitation also is
Oh,
there.
that is the subsection 3.
Yes, my lord.
No.
Three,
That is,
two,
no, subsection 2.
two, my lord,
Proviso,
my lord.
provided that no such land shall be restored to the possession of the, there has not been any claim.
My lord.
Yes. So according to you, that document
My lord,
will suffice.
My
That
lord.
is that is to be taken as sacrosanct.
my lord.
Anything more to be submitted?
That's all. My lord.
That's all.
But I'll add a few things.
Hmm.
But 152 proceeding, if they say it's under a 152.
Hmm.
In the opposition, they must substantiate it with an order being passed by the subdivision officer. Because such authority, who is the authority to hold amendment, it's a subdivision officer.
Hmm.
But no document has been filed in the opposition showing that any inquiry was done in terms of 152. Upon adhering to the provisions as contained under 142, finally order was passed.
Hmm.
Now, this 152 is not the resumption. It can't be resumed because
Under section 142.
no 152.
152.
It can't be resumed.
Hmm.
Resumption is something which the government takes permanently.
Hmm.
But 152, for non-compliance of certain conditions, the authority can take it if within statutory period mentioned there, if
3
certain
years.
things are done, it will be restored back to the owner.
Restored back to the owner.
My lord, that's all about 152, entire subclause.
152, yes.
There is no document forthcoming from the side of the respondent showing that any inquiry in fact was held by subdivision officer. Look, Tahsildar in hierarchy is a subordinate revenue officer. I'll show section 3.
Hmm.
Subdivision officer is superior officer. So inquiry has to be done by the subdivision officer, not by the Tahsildar. But the record which I have challenged, more particularly the remark column, has been prepared by the Tahsildar, not by the subdivision officer.
1 minute.
Regulation 3 may kindly be seen, my lord.
No, no, it is the order of the deputy commissioner.
Learned counsel, take note of his
My lord.
submission. You will get the opportunity to give reply.
My lord,
Subdivisional officer.
Can we see regulation 3?
Yes, regulation 3.
My lord would find D. It's assistant commissioner.
Assistant commissioner.
Yes. My lord, kindly pause more. My lord, now kindly turn to regulation 10. Next page, 10 may kindly be seen. Who can be a subdivision officer? 10.
10.
The chief commissioner, who is the present LG, may place any assistant commissioner to be the in charge of one or more subdivision of the district, who would be subdivision officer. My lord would see
May place any assistant commissioner.
whose name my lord would see at 3. 3 D.
From D.
D. So any assistant
D.
commissioner in this island is a subdivision officer.
Charge. We are having pleadings.
I'm so sorry.
The atmosphere should be conducive.
I'm so sorry.
Yes. So the chief commissioner may place any assistant commissioner to be in charge of one or more subdivision.
Who would be classified as subdivision officer? Not say remark that's margin, right?
Subdivisional officer.
Subdivision
Yes.
officer. So this power has to be exercised by the assistant commissioner. There are those documents coming from the side of the respondent. Simpliciter saying that it has been abandoned will not do lot. It's an official act.
And on the contrary, it has been issued by Tehsildar.
Who is one of the hierarchy officer in section 3?
Where from you will,
Section 3 F.
No. Where from you will get that it has been issued by the Tehsildar?
The records are being prepared by the Tahsildar. But the records, the entire records, more particularly the remark column was prepared by the Tahsildar.
Page number?
Yeah, no, it's a writ petition. Page number is 33, which I have given the type copy.
33.
Type copy just now I have handed over.
1 minute.
It is duly countersigned by the Tahsildar. Now, you see at the bottom. And these are the records being maintained by the Tahsildar office, not by the subdivision officer. My lord, at the top, my lord would see Form F. And I will show, my lord, who maintains this Form F under this regulation. Form F is maintained by the Tahsildar. My lord would see at the top, it's under Form F. Rule 132. I'll show that rule 132. It's the Tahsildar who prepares this record. Subdivision have no business to play while maintaining this record.
It has been signed by Patwari,
Yes, he is subordinate to Tahsildar.
subordinate to the
Yes.
Tahsildar.
Even he is the revenue officer under section 3. Patwari, revenue inspector, surveyors,
But not by SD.
subdivision officer. I could not. These entries have to be made corresponding to certain records. Certain proceeding ought to have initiated under regulation 152.
Yeah.
Where are those? But opposition, in the opposition, they cannot improve it. Mohinder Singh Gale's case, my lord knows. If there is any decision taken, first they have to take a decision, my lord, under 152. An order needs to be passed. Then the corollary act would be the record correction. Where are those orders? I'm asking myself. And nowhere from the impugned remark column, anywhere it says that in exercise of power under regulation 152, this has been done. They use term deserted. Nowhere under the regulation, my lord would find this term deserted. It's an alien to this regulation, this deserted, resumption. Where from they get, my lord? It's nothing but the colorable exercise of power of the Tahsildar concerned. And my lord, as of now, the property is in the name of my father. Government names have not been recorded also after striking my father's name. If let's go with the submission by my adverse side for the sake of argument, but not admitting it also.
But recording the name of,
My father only, as of now. If I accept
where from it will reveal.
the same record, the one which I have challenged, page 33, for which I have given a type copy, my father's name still record Fakir Chowkidar. I could have understand amendment was done, my father's name struck down, government revenue land recorded. I can understand. Leaving aside the documents which I am asking for now, where is the order of amendment? Even some credence can be given, but still my father's name is recorded. How then it can be said, ownership, it has been amended, it has been taken by the government in their name? Lord, on the point of limitation. And on the point, on that day, he argued that I have not given a representation. I brought the judgment of Supreme Court, I would rely. The Supreme Court said, three judgments, celebrated judgment, that if a decision is taken, the representation would be an idle formality. Post-decision hearing is a futile exercise. Supreme Court has condemned it. Once they have, the authority have taken something in their mind and they have taken a decision, it's an empty formality. Nothing would fetch. No decision is taken, I can understand. I have to file a writ, demand notice have to be given. I can understand those things. But once they have already issued the impugned remark, that means rights have been affected, my rights have been affected, then the demand notice is it's a mere idle formality. I have brought that judgment. I'll place it now. Now, it's the first judgment is of 1987.
How many judgments do you want to?
Now, 3 judgments on this post-decision hearing.
Why
Three.
3? Why only one?
I'll cut it down. I'll cut it down.
Which one upon
Yes,
which you are
yes.
relying?
Yes. Yes, it's of 2006, 12 SCC 33 by their Lordship Honorable Justice S.B. Sinha and Honorable Justice Markandeya Kajju. Now, I'll just show, because in this judgment, those 2 judgments which I propose to rely has also been discussed.
Relied.
Yes, my lord. My lord. It's paragraph 10. Page 36, paragraph 10. But to be very candid on my submission, the old judgments of Supreme Court, Lord, it's not my comment, my lordship. My lord. But paragraph 10.
Paragraph 10.
10. The
The
said
said principle
has been followed by this court in VC Banaras, Hindu University versus Srikant. So that has been reproduced. The vice chancellor appears to have made up his mind to impose the punishment of dismissal on the respondent. A post-decisional hearing given by the High Court was an illusion in this case. Next judgment. In K.I. Sippert versus Union of India, this court held, it is a common experience that once a decision has been taken, there is a tendency to uphold it, and a representation may not really yield any fruitful result.
So according to you, post decision is
Going to fetch any result because they've already
will
taken
not
an
be-
adverse decision.
not be helpful for the aggrieved
Absolutely,
party.
absolutely. And Lord, I can place these two judgments. It's a judgment on the proposition. Aptly, several things have been discussed of this separate Banaras Hindu University and this KI separate judgment. But those two I'm not then relying on. So then on the point of limitation, my brother has vociferously argued that my writ petition needs to be dismissed on the ground of delay and laches. Not aptly on the point by the Honorable Supreme Court of India. I'm just placing it, Lord. Lord, it's paragraph. It's in the case of Vidya Devi versus State of Himachal Pradesh and others. I'm placing it 2020, Volume 2, Supreme Court Cases 569. Madam. This is dealing with a right of a citizen under Article 300A of Constitution of India. And this submission was recorded, my lord, on the last occasion. Just 1 second. My lord, it's 12 point. Just 1 second. But 12 point. Just 1 second. My lord, 12.8, 12.12 to 12.18, 12.8 to 12.12, and then paragraph 14. I'm just placing at page 574. There the case was for a compensation. A widow lady approached
12.8.
my lord. Kindly see 12.8, page 574. 12.8 and 12.9. I'll just rely upon this.
12.8. Yes.
My lord, the contention of the state that the appellant or her predecessor had orally consented to the acquisition is completely baseless. We find complete lack of authority and legal sanction in the compulsory divesting the appellant of her property by state. In a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without sanction of law. Reliance is placed on the judgment of this court in Tukaram Gana Joshi versus MIDC, wherein it was held the state must comply the procedures for acquisition, requisition, and any other permissible statutory mode. The state, being a welfare state governed by the rule of law, cannot arrogate to itself a status beyond what is provided by the Constitution. Lord, kindly see, the modes must be adhered to. Then, my lord, 12.12 at the bottom, same page. The contention advanced by the state of delay and laches of the appellant in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of continuing cause of action, or if the circumstances shock the judicial conscience of court, conscience of the court. The condonation of delay is a matter of judicial discretion which must be exercised judicially and reasonably in the facts and circumstance of the case. It will depend upon the breach of fundamental right and the remedy claim, and when and how the delay arose. There is no period limitation prescribed for the court to exercise their constitutional jurisdiction to do substantial justice.
It has been passed on, this order.
Which one not this order? If I go with this remark column, sometimes during 1980.
1980.
Yes. I mean, still my father's name recorded in terms of their own admission, be it forcefully, I'm in possession.
Where from you are getting 1980?
Not to see the type copy, the type 1, the holding has been resumed. The type 1, I can give one more copy, not?
No. The type copy.
Well, at the bottom remark column deserted below, the holding has been resumed wide order 14/4/1980. Malad have given the type. Malad is looking into the my copy in the petition, which is ineligible. Malad kindly have a look to the type, the loose sheet which I have given just now. 1-page loose sheet. That is the one. That is the one.
The holding has been resumed wide order 14/4/1980 of the DCFCC.
Deputy Commissioner file case recorded in sheets 5 corresponding revenue case number so and so corresponding to QRS number so and so. Tahsildar Mayavandar, ICM in charge Mayavandar. They admit my possession over the land in question, Lord.
It is dated 14/4/1980.
14/4/1980. It's a continuing cause of action. I'm occupying it. Property is still in my name, my father's name. It has not been struck down.
Who is in possession?
They admit it in the opposition. It's my case. They have admitted also. I'll show their opposition. But they say that I have forcefully.
Wherein?
What sometimes what happens?
No, only one thing. Hey.
Hello.
I'm sorry. I'm so sorry. And not paragraph 14, last line. Paragraph 14, last and after. Malad would see. Paragraph 14, last line. And after demise of recorder tenant, his wife, son, and daughter of late Fakir Chand, they have said Vishwas had forcefully entered into the suit line into the land during the year 2003 and residing over the land, and they have raised plantation such as fruit breeding trees, banana, areca nuts. So they admit my possession, but they say that we have entered into the land forcefully. My possession has not been denied. The records as of now stands in the name of my father. I'm one of the son. So mainly these are two judgments on the proposition of law, lordship. Delay and laches will not come, at least in this case, because it varies case to case. Particularly the present facts involved in the writ petition, recording of my father's name, being maintained the possession, their act of not taking the property in terms of the statutory mode as provided under regulation 1966.
So what is your prayer?
But my prayer is, not kindly turns to my prayer. Now, to kindly see the electricity bills and all showing that I'm in possession. On that day, I've shown it photographs. I'm doing the pack.
Electricity bills.
Ranjit Chaukidar names,
Assistant in office of the assistant engineer.
Yes.
Subdivisions 31/32.
Yes, my lord.
Any present electricity bill?
It's there, my lord. Last one I can show 20, page 32, 2023 bill. It's there, still there. And it's not their defense also. They admit my possession, lordship. And next, my lord, my prayer at my lord would find at paragraph page 12,
Hmm.
to annul or to set aside that remark column wherein it has been recorded that it has been resumed. Rest part need to be maintained. It's in the name of my father. And para 2, my lord, directing the respondents authorities to allow
What does the word resumption?
nowhere, my lord, it's there. Nowhere under the regulation is there. No, they can, that's what I'm saying. The statutory mode is provided under the local regulation, special statute. This is 1966 regulation. My lord will not find anywhere this term resumption. If I go with the dictionary meaning, resumption is to take back.
Hmm.
Resumption is once given by the authority, it's to take back permanently. But there has to be some established procedure, which must find in the regulation 1966, my lord.
Anything?
That's all, that's all. I pray for
My lord,
Allah's repetition.
In reply.
My lord, there is one more regulation, 162, page number 33,
Page number 33.
extinguishment of tenancy. LR.
Page number 33.
33.
33 is the record of rights.
No, my lord, the land record revenue regulation.
Oh, regulation.
Section 162.
Yes.
The interest of a tenant in his holding or any part thereof shall be extinguished. A, B, C, D is not relevant. E is also not relevant. When he has been deprived of possession or his right to recover is barred by limitation. None G, when his holding is declared as abandoned. So in this case also, he has abandoned the land and as such, it has been resumed. Number one. Number two is that the petitioner vehemently argued that the land is still recorded in the name of his father, that is denied. Because the record of right, which page number 33 is of 1981, the old one. They have not submitted any of the record as on date, current record, because there is no record in the name of Fakir Chan as on date.
Have you produced? Through your affidavit?
Yes, in page number 8. Page number 8. Page number 8 is in Form AN.
1 minute. Yes.
Form AN, it is issued under Rule 176, where is that this is an unoccupied land available for disposal. Survey number may be seen, serial number 726. In the remarks column, it is allotted to Sri Anand and 9 others, white such and such. So the name has been changed. Now this survey number 26 was allotted to Ananda on 15/4/1999. These records which my learned petitioner has relied is way back old one, subsequently before resumption. After that, there is no record in the name of the petitioner or petitioner's father. And next one, serial number 8, server number 27, remarks land surrendered for construction of sign motion, while RC number 148/82. Thereafter, next page is server number 70. Serial number 13, server number 70, remarks column, land surrendered while such and such 10/2/1989. So as on date, the name of the petitioner's predecessor is not there in the record, as my learned friend has submitted. And they have never challenged these entries also. Yes, as per regulation 162, the right has been extinguished. And The petitioner also submitted that this record has been prepared by Tahsildar. This certified record has been issued by Tahsildar, but the remarks column, it is clearly mentioned the authority who has passed the order. The holding has been resumed while order dated 14/4/1980 of Deputy Commissioner.
Where from it you?
The single page document which my learned friend typed copy
Today.
today.
Achha.
The holding has been resumed while order dated such and such of Deputy Commissioner.
Oh, DC.
Yes. It is not the Tahsildar. As such, the right of the petitioners have already been extinguished as per regulation 162.
Yes.
And the right to recover his possession is also barred by limitation at this stage.
What why recovery of possession? I will seek for my land.
Yes,
What submission you are.
it is not your land, no more your land.
Same type.
Same. She's one of the daughter of
Oh,
Chokidar.
acha. He has one son, one daughter.
Yes, she's the one.
She is the daughter.
Yes.
And for that one was the son,
No,
Ranajit.
sons are more than one.
More than one.
Yes.
Acha.
Ranjit.
So passed over. Ranajit.
Ranjit, then Ravindra Chowkidar, my lord. Kamala Mandol, Bimala Pitwania, there are 7 children.
All these applications are here,
Oh, rest are before the court number 1.
disposed of.
No, not even started.
What?
It has not been started.
My lord, in this matter, let the matter be posted to the next circuit, my lord. May not be possible for this circuit, my lord.
It come on Monday. I will not bother, my lord.
Okay, appearing for respond number 2, I'll seek one copy here.
By all means, I will give on it. Let it come on Monday.
Not possible, my lord.
Next circuit.
Last
so
date.
it's a flag and let it be on the next.
You are appearing on behalf of
For respond number 2, respond number 2.
Shaji Varghese. Have you filed Wakalam number?
I don't know the dates.
Mrs. Appears on behalf of the respondent on behalf of the private respondent. That is the
Both are
respondent.
private.
Next circuit 9.
Your lordship, in this matter, Miss Babita Das is appearing for official respondent, Your Honor.
9.
Yes.
On the submission of Mr. Jaipal, learned counsel representing the petition. Here for the petition 10.
11.
11. M. Devi.
No, yes, ma'am.
M. Devi. You are representing municipal.
Respond. Yes, ma'am.
All.
Yes,
One minute. Let's ask.
yes, ma'am.
Yes. Yes.
Additional here we have to allotted a shop complex in the municipal market by the respondent, by the municipal. Market. It was allowed, this shop was allowed way back, sometimes.
We have heard in respect of the petition being filed by Mrs. Anjali Nag
This is
in respect of fruit vendors.
fruit, man. This is vegetable.
This one is vegetable. Vegetables.
Different matter.
Facts are different.
Facts are different.
Yeah.
Yes.
That's it.
Here the issue is different, my lord.
Acha,
Here-
let us
let's
submit.
That
What is the prayer?
my thing is that at the time when this allotment was done, subsequently, my clients they were using, because you know, it is obvious, my lord, when a shop is being granted, given the veranda which is in the front of that shop, usually it is used by the shopkeepers. They used to give their utensils over there.
Do you have any picture here?
Passage has been blocked.
If it is, that's the question.
My-
If it is for the purchasers, if the plot is not the plot, the space allotted for the purchasers to pass by, then can it be encroached by the vendors?
Liberty was granted. This liberty was granted to them, I enforcement
You are paying rent in respect of,
in respect of shop, and subsequently they
No.
have
do you have any document to show that you are paying rent?
my lord,
Which page?
page number 28.
28?
It's, I have
Place it.
the second sentence, accordingly, the documents were verified and demand of.
Slowly, Learned Counsel.
Accordingly, the second sentence.
12 and 13 are similar?
Yes,
Facts?
ma'am. Yes,
Similar
yes.
facts.
11
So, if one
12
can
or
be disposed of,
13.
12 and 13
Yes,
can be
yes,
disposed
ma'am.
of. Slowly.
Accordingly, the documents were verified and demanded for the position of NRT of rupees so and so. 1,50,000 was raised for producing transfer of tenancy right to the shop situated at New Mohnpura Vegetable Market. Since you have paid the transfer penalty charges with regard.
Learned Counsel, Learned Senior Counsel, what for the penalty? Amount of rupees 1,50,000, 1,05,000?
My lord, this kindly, this says,
Transfer of tenancy right of shop situated at New Mohanpura Vegetable
this I have
Market.
to ascertain, but this is not a dispute. They are relying on this document to show how they have come into the.
Acha. You have purchased,
Shop was allotted to someone. I was as a tenant of the original allotee. Subsequently, I approached the municipal council and they have transferred the right of original allotee to me. This is the document whereby.
This is not, my lord, this document they are relying upon only to show that they were directed to execute an agreement on stamp paper of rupees 20 within 15 days. That is how they got the tenancy right, my lord. They are just showing to that
So,
purpose.
you are the tenant under
Municipal.
Port Blair Municipal Council. There is no dispute as.
No, there is
the
no
fact?
dispute on that.
Yes, subject to payment of
Some rent.
Learned Counsel.
How much?
How can you say some rent and in respect of some land? Can you say so?
That the rent is not in enforced now. But they are not disputing that shop has not been allotted to me.
There is no dispute. That is admitted fact. Shop has been allotted, but the rent receipt is required.
So I can produce it by Monday. Because tenancy has been transferred to me and my position is not being challenged.
No. Learned Counsel. Yeah. Notice, whereas it is found, page number 34. Whereas
30,
it is 34.
31 also, my lord. That is
31,
first
relevant.
one. 31 may be seen.
Page number. Whereby the tenancy has been transferred in my name.
Yeah.
So previously,
Learned Counsel, that first chapter is over. You are in possession, you are the tenant directly under the municipal council. Now we are concerned with the extent of tenancy. We are concerned with extent of tenancy. What is your prayer? What is your prayer?
So, my lord, their cause of action is, my lord, this page 29 at 31. This, my lord, will see this document, my lord. I'll just assist the court. This is a letter dated 22nd October 2011, my lord. Issued
29.
2011. Yes, my lord, page 29.
Uh-huh.
Now kindly see this with reference to Secretary New Vegetable and Fire Victim Market Mohanpura, dated on the above side inform you the aforesaid matter was taken up and it is resolved to allow the above shopkeepers to remove the hollow block wall and to fix glass rolling shutter above the sill level as per the terms and conditions below. One, the shop.
Learned counsel. Let me go through. Dismantling of filler wall. What is filler wall?
It says dismantling the wall from sill level,
No.
from floor without
Subject. Dismantling of filler wall above SIL level. What is filler wall and what is SIL level?
Then I have to file an affidavit, my lord. I've just now received the brief, my lord.
But previously, they have taken the position of the veranda. They have raised the wall, and above that one grill was there. Subsequently, this matter was placed before the municipal council. They have given this relaxation to the vendors. Okay, you remove the grill, and the wall should be only 77 centimeter, and above that you have to put rolling shutter. In the year 2011, this permission was granted.
A picture would have clarified each and everything.
So now, my lord, what they have done is at page 32. Kindly have 32, my lord. Whereas shop number 2.
Let me understand. Generally, what do you have? Walls on three sides. To the extent of height of the walls. Height of the walls.
It is maybe 6 centimeter. The normal height of a room.
Basically 70 centimeter wall. 70 centimeter.
Dismantle the wall from sill level. I am unable to understand what is sill level. That is 70 centimeter from floor.
Kindly see the petition they have explained, my lord. Kindly see page 7, my lord, in the petition.
You are the advocate on record. So your client must have explained to you each and everything. Page number?
Kindly see page 6 onwards. Page 6, para 5 onwards, my lord. They have explained it. Then para 4.
1 minute. Paragraph
4.
5. Paragraph 4.
5, I think there is a mistake. Para 4. Meeting the grievances of allotted shop owner. May I read, my lord?
Yes.
That your petitioner states that in that meeting, grievances of the allotted shop owner for use of veranda of the shop was resolved, and it was decided that shopkeeper should remove the hollow block wall from level, i.e., 70 centimeter from floor without disturbing the structure of the building, and to erect, install, and to fix glass rolling shutter. So they were directed to have a shutter on the front side. Then my lord will say see the para 5 that your petitioner states that after getting the aforesaid permission, petitioner herein had complied the direction of the respondent authority and had installed a rolling shutter above 70 centimeter wall from floor level in the veranda portion and was doing the business. That your petitioner states that prior to the aforesaid meeting, petitioner had covered the veranda by putting walls and grills. As per the order, grill was removed and rolling shutter were installed, covering the veranda portion in front of the allotted shop. That your petitioner states that was further submitted, it was further directed by respondent authority that cost of shutter will be raised in veranda portion borne by shopkeeper, and in addition, no projection chhajja should be done by the allottee in any circumstances. Your petitioner states that abiding the terms and conditions, petitioner installed the roller shutter above 70 centimeter wall raised from the floor at his own expenses and was doing the business. That your petitioner states that he is in possession of 3 shops consecutively, and above said 3 shops are in each corner of the premises, and from the veranda of the above 3 shops.
And the above said 3 shops, the third line, 3 shops are in the
end corner of the premises.
End corner. So at the 3 corners of the premises.
Yes.
At 3 corners of the premises. Achha.
And from the veranda of the above 3 shops, the other shops of the premises cannot be approached as it is blocked by staircase for first floor. The petitioner states that on 18 December 2023, the respondent authorities had issued a notice that petitioner is found to have occupied the veranda in front of the shop by fixing rolling shutter without any permission from the respondent authorities. Now kindly see, my lord, these letters which are at page number, my lord, may have page 32.
Annexure P3.
Yes, my lord, page 32 onwards. Page 32 onwards, my lord, may see.
Number 2 is allotted to PL baby. Whereas it was found that you have occupied the veranda in front of your shop. You have occupied the veranda in front of your shop and has fixed rolling shutter without any permission from the Port Blair Municipal Council. Whereas you are now directed to reply to the notice within 15 days. This one is the.
And they respond to this. Kindly see their own admission on the next page. In response to your above referred show cause notice, I am to reply that on my specific request on many occasions, I have been allowed to fix the rolling shutters for my shop number such and such, re-allotted in my name, and shop number 1 and 2 re-allotted in my husband's name, which are lying serial wise in a line at one side at the new vegetable market. Hence, I fixed the rolling shutters by covering the small pieces of veranda space, approximately 2 square meters, lying idle and vacant in front of my shop number 1 and 3, which was being utilized in the night hours by some antisocial elements for their nasty practices, and the place for natural calls and rest of the stray cattle absolutely day and night, which disturbed our valid customers and loss of my business. Then he says, I'm ready to pay monthly rent for covering the space of the veranda of my respective shop as per rules and regulations. Then my lord will see after that, page 34. Again, my lord, notice is given. And then my lord will see further notice is given at page 35 and 36.
Observe that
These are only notices, my lord.
Rolling shutter is against is against terms and conditions of the allotment order of the shop. So rolling shutter. The prime concern is the rolling shutter.
My lord, that is occupying the
For which permission
common area.
by the respondent
So
authority.
you are directed to remove the rolling shutter. Is against terms and conditions of the allotment order of the shop.
My humble submission is, my lord, this is no, it may help them. It is my humble submission is only notice, my lord. They can appear before the authority, make their representation, my lord. The authority can decide in accordance with law.
Chance of hearing may be great.
Yes.
Chance of hearing.
In respect of 11, 12 and 13.
Yes, yes.
In Mr. Bukshi.
May not be at my concession, my lord. My lord.
So treat the
Consideration.
writ petition
Yes, yes.
as a representation and to dispose of the same after giving
My
opportunity.
Yes, yes.
Certain notice. No, the past over, no, it was past over matter, there's a past over matter.
And for the respondent, my lord.
Hmm.
On.
One matter has been disposed of. With having the same fact.
My lord, something I would like to add, my lord. Thanks, sir. Yes, it's similar to item number 6.
Similar to item number 6.
My lord.
Oh,
Item number 6.
yes. Which was,
7.
Yes, item number 7 is similar to item number 6. Same order.
no, one
No,
thing,
not same. mother.
one thing.
She is the daughter.
She is the daughter
Yes, she is
of
the
that,
daughter.
Patik Chand Naki,
Yes, Fakir Chand.
Fakir Chand. Anything to be changed?
Change, my lord, it's
Achha, it-
hopelessly because there is no order to that effect, my lord.
Which one?
Fine. But
On the
one
basis
point
of
I would
the-
like to mention, my lord, regarding its limitation ground, my lord, because it's hopelessly barred by limitation. I think 34, 35 years after 34 years, they have come before this honorable court, challenging that entry, which has made in record of rights in way back in 1980. So more than around 40 years.
To that effect, learned counsel,
And similar case, my lord, coordinate bench has decided on this issue regarding delay defects equity.
yes, that is
I
also
was there.
fact.
I was present and some other advocate was present. Similar type.
But as there has been,
In this case, it was the case of surrender.
but as there has been contention that
Yes, yes.
on your
same,
behalf,
same.
on your
No,
behalf, same,
this
which
case is also
which is
stands-
contrary to your submission on the one side, and does not corroborate, both the statements do not corroborate each other. They do not go hand by hand with each
My
other.
lord, record speaks otherwise, my lord. If they are in possession, they are illegal encroachers, my lord. They're trespassers. We can say they're trespassers because their land is no way now has been recognized by the revenue authority as their own land. It has already been abandoned. So, my lord, the court has to be corrected. And if though not ending the behavior, we cannot go beyond what is there in the.
Can you go beyond the
my-
affidavit in
my-
opposition
I do it,
in the same context?
my lord.
If-
Even we
if-
have forcefully,
if
we
that-
have, we have stated
that had been-
forcefully they have entered. That means they are trespassers,
If that had been in respect of any other person,
my lord.
not the legal heirs of Fakir
is-
Chand,
It's legal heirs of Fakir Chand.
Fakir
It's
Chand.
not the Fakir
They-
Chand. And we have.
and they are possessing, whether it be legally or illegally, in respect of the same land, which is also issue in item number 6.
My lord,
So the same order is to be.
if the original allottee,
Hmm.
he is not entitled, how the legal heirs will be entitled? How it can be heard, refresh, my lord? Because the predecessor, his right has been, I can say, extinguished. His right has been extinguished. Then how the legal heirs can revive his right over the right
If-
of the
if
father who has
there-
already been.
If there
abandoned.
had not been, if there had not been the affidavit in
My-
opposition,
My
then
lord,
the
if affidavit in
then
opposition, my lord, if my lord sees.
you have the authorities
Yes.
have said
Yes,
some
course.
things,
My lord,
some things
my-
which goes against. They have stated that the Fakir Chand had surrendered or something. Thereafter, in the year 2003,
Then, no,
after
sir,
the
it's not a
demise,
case of
after
surrender. He has never
after-
occupied that particular land.
so something
and
has been
subsequently
stated.
it was-
Something has been stated in the
Fine,
affidavit in
fine.
opposition. And in the year 2003, on the demise of Fakir Chand and his wife, this that's petitioner of item number 6 and daughter, there may be more than 2, have forcibly, as the term has been applied, mentioned, forcibly entered into the possession,
Now they're-
entered into the property.
You can say they are the trespassers. They cannot be associated with any, like, have got a legal right or because their predecessor has right has already been extinguished. Now they
It
can
is-
claim their right
And you
over
have
the right of the
specifically
father,
mentioned-
which has already
You
been
have
extinguished.
specifically mentioned in addition to that,
My,
that it is of the year 2003.
my,
More than 20 years have passed by. That's why the matter, nothing more to be said from here.
also, I would like to add on that point, Milo, regarding the delay, it's undue delay. Because there was no explanation for such delay, my lord. In the writ petition, if my lord sees, there is no explanation for such delay.
To
But
that-
may kindly see on that aspect, because
To that effect, a citation has been placed. Which one, that Varanasi Hindu University? No, that one, it was in respect of delay and latches in respect of some other another citation has been placed. Vidya Devi. 12.8 and 12.9.
My lord, in this matter, if my lord sees
Same contention.
the
12.8, the contention of the state that the appellant or her predecessors had orally consented to the acquisition is completely baseless. We find complete lack of authority and legal sanction in compulsorily divesting the appellant of the property by the state. In a democratic polity, government by the rule of law, the state could not have deprived a citizen of their property without the sanction of law. Reliance is placed on the judgment of this court in Tukaram Kani Joshi versus MIDC. 12.8 and 12.9 has been placed.
My lord, I would be emphasizing on delay defects equity, my lord. This is applicable in this writ application, my lord, because if my lord sees there is no such order which he has challenged. It's a wrong entry or as alleged by the writ petitioner, which has been made in 1980, my lord. And the delay has not been explained. Whether this judgment is applicable in this case, no, my lord.
If anything is void ab initio, then whether limitation once again, I'm reiterating that if the affidavit in opposition would have been filed
That reason we
Same.
did, and for that, my lord, my submission that is a trespasser, and we have stated that it's forceful occupation of that.
so in that case,
Take steps, my lord.
Steps
We are taking steps, but in the meantime, they have come before this honorable court.
same order in 7. Lord Council. Same order as in 6.
I'm for the respondent.
14 next circuit. On the submission of take his name. Mr. And submits that and submits that
And 15, I appear on behalf of the official respondent, respondent number 1.
same order.
Item 16, automatic salam of 24. Not being affected. Maybe we put on next circuit.
Huh?
Maybe we put on next circuit.
Next circuit, item number 16. 16. Same order. Submits at the service has not yet been affected. You tell your name to me. I will dictate to him. Your name?
Numerical correction in order. Page 16.
1 minute. Item number 17.
17.
Shobha Devi.
Order dated 13/11. Page 6. You know, see, there the circle number, there 2504/1/2/2. This may be /3. Because
I couldn't get. What is?
page 6, you know, the order dated 13/11/24. WPA 174. The petitioner is agreed that the demarcation for her plot measuring about 0.245 hectares under.
0.25 hectares under survey number 2504 by 1 by 2 by 2 has not been completed till date.
You know, see, this may be 3, 1/2/3. Because page 5 is my representation to the Tehsildar for demarcating the land.
Place the petition.
Page
Please.
5,
Place the petition. Place the petition.
page 5.
Place the petition.
Writ petition, writ
Read petition.
Read petition.
Read-
No, not can one.
Can. It is page 5.
writ.
Can one, page 5.
Paragraph number 1. You place paragraph number 1.
That your petition is the resident of village South Point and record plan of cost tax survey number this. But this was not issue. Footpath survey number was the issue.
Learned counsel, you are well aware of the facts and circumstances. The court is not aware of the facts and circumstances. You will have to apprise the court as regards to the fact. Then the court will be aware.
You not see in a AO,
This
the
is the,
respondent has taken this point.
this court, this bench is hearing this matter for the 3rd time or 4th time. This bench,
Only first time.
first time. Then
Then
you will have to apprise the fact.
your lordship. So if you not see this, my client filed a petition to the Tehsildar, that is page 5 of the 10. To the Tehsildar, Port Blair, South Andaman. Subject demarcation of survey number 2504/1 by 2/3 and 129/2/P at South Point Place.
What was your prayer in the
Prayer,
what was your prayer in the writ application?
demarcating the footpath land and fixing the pillars.
The writ is not with me, if you can show.
1 minute.
Copy I have, sir.
Writ.
Read.
The prayer in the writ is matches with the request in the modification, then my lord
This
can
is to
pass
be
it.
done by this bench or?
Perhaps by the bench which passed the order.
Yes, as far as, as far as I could get,
My.
I think there is a discrepancy as regards to 2504 by 1 by 2 by 3. It will be by 3, not by 2.
That is what he submitted.
Hmm.
That
AO
can
is
be,
also
Can
I
be
say-
checked from the writ only, my lord. If the prayer in the writ is the same, then it
But
can.
no, prior to that, whether this bench can do
That, my
that
lord,
thing.
my impression is also that it should go to the same bench, my lord.
This bench won't be able.
Why no, no? Modification correction has to go to the same bench. No, modification correction review also has to. I don't know, man. My impression is that this is like a review of the order, no?
No review.
Modification of order.
I'm not asking.
Whatever, I am not
additional-
saying,
additional-
suggesting anything, whatever is the rule should be followed.
No,
my-
the rule is that modification by the same bench,
Yes, my lord. Correct.
same
Absolutely.
bench.
Let it go to that bench, my lord.
As regards to this being a bench situated.
No,
away from
that
mainland,
principle, same principle.
Same
applies.
principle.
That is not.
Through virtual mode, it can
Yes,
be.
yes. my lord.
But that is my view. I don't know whether that is being followed or not.
My lord, I can ascertain, my lord.
Same bench.
Same bench. it
Same
is,
bench
senior
which
member.
passed the
Yes, yes,
order.
yes. Learned.
Learned counsel, you will have to file before the place it before the Honorable Chief Justice.
It may be sent to the same bench. History may be direct. History may
This
be directed to.
this court doesn't have that power.
You
This
My
bench
lord,
doesn't have
my
that
lord
power.
can place it before the Honorable Chief Justice to. That can be done. That is usually done here.
History may be directed.
Registry is
uh,
directed subject to the orders of the Honorable Chief Justice to send it to the bench
uh,
of Justice Judge
through
Shekhar
the,
Monk.
through the
Item meeting essay 1 of 2025.
Let it be next circuit, my lord. This paper book we are
next
receiving.
circuit. Next circuit.
When I appear on behalf of the respondents, I have filed my opposition. Appeared in opposition, I filed before the registry. I'm here.
Absolute opposition is there. Who is representing the petitioner?
My lord, let there be an order to the effect, my lord, that I am filing.
Be kept to the record.
So,
Any order required?
yes, my appearance will be recorded.
Um, the respondent.
Senior advocate, petition.
Next circuit.
No. Affidavit in opposition has to be filed with us.
My lord, may kindly see on record, I have already served also. And now they're taking point that it has to be affidavit in opposition already on record, and they have been served also on 10/12/2024.
I pay for 10 years time for it. Affidavit.
Madam,
So why did you submit that
yes,
they are to file affidavit in opposition?
without going to the records, they're submitting, my lord. It has already been filed and it has been served on 10 December 2024.
Affidavit. The
October 1st October 2024 order may be kindly seen, my lord. I filed opposition.
And 21 WK 475/2024. Just now. 21 I have.
I appear on behalf of respondent
No, no.
number 1.
Yes.
क्या करना है इसमें?